Good afternoon, everyone, and welcome to this webinar with an update on the off-payroll working reforms that will apply from 6th of April 2020. I'm David Williams-Richardson, and I'm joined today by my colleague Lee Knight for this presentation. Proposed new rules that we're going to cover represent one of the most significant changes in employment legislation for many years. As you'll see as we go through the presentation, there are many things that you need to consider which are going to potentially impact all areas of your business. There are now only about 6.5 months to go before the new rules apply, but it is important to add that today's presentation is based on the draft legislation which was published in July this year. Unfortunately, we're not expecting the final legislation until November, so please do bear in mind that what we're covering today is subject to change. Before we get started, I just want to confirm that you can submit questions today, and you can submit those throughout the presentation, and we will try and answer as many of these as possible at the end of the session. Questions can be submitted by clicking on the Q&A function button that you should be able to see on your screens right now. If we don't get an opportunity to answer your specific question, or if you prefer to speak to either myself or Lee direct, then our contact details are shown at the end of the presentation, or of course you can speak to your normal RSM contact who will be pleased to help. So in terms of the background to all of this, this so-called IR35 legislation was originally introduced in 2000 with the intention of ensuring that workers who decide to operate via intermediaries such as a personal service company should broadly be paying the same amount of tax and NIC as an employee. It's important to make this the point at the start that this legislation can in fact also apply to workers operating through other forms of intermediary such as certain partnerships. But by far the most common form of intermediary is certainly a personal service company. So throughout today's presentation, we're going to focus on personal service companies. So a significant flaw with the original rules has been the fact that the onus has been on the personal service company itself to self-assess whether or not these rules apply. HMRC estimate that there is up to 90% non-compliance at the moment, which they believe will result in lost revenue of up to 1.3 billion a year by 2023-24 in the absence of these changes. So in order to start addressing this non-compliance, the IR35 rules for public sector end users was changed from 6th of April 2017 put the responsibility for deciding whether or not the rules apply onto the end user of the services rather than the personal service company itself. The reform for the public sector also made the fee payer responsible for accounting for the income tax and the NIC, including the additional cost of employer NIC, where it was found that the rules apply. The government, perhaps unsurprisingly, believes that this reform has significantly increased compliance as well as increasing revenue, and now intends to extend the public sector reform to engagements with medium and large organisations in the private sector for payments from 6th of April 2020. It's important to remember that this new legislation applies to payments, not to new contracts, or not exclusively to new contracts from 6th of April. The legislation from 6th of April 2020 also includes some important changes to the existing public sector rules that public sector entities are going to need to be aware of, and we're going to cover that in a bit more detail later. It's important to note finally that these rules apply to the provision of services via intermediaries such as personal service companies. So the changes we're discussing today do not impact existing obligations that you have to determine the employment status where you engage a self-employed individual. So what is actually changing from 6th of April 2020? To summarise, the new off-payroll working rules are going to apply where payments are made on or after 6th of April 2020, where a worker is personally providing services via an intermediary such as a personal service company, and the end user of those services is either a public sector entity or a medium or large private sector business. The rules are not going to apply where the end user of the services is a small private sector business, and Lee's going to talk through the qualifying criteria for a small business shortly. Under the new rules, the company that is using the worker's services, the end user, will need to assess each engagement and decide whether or not the worker would be deemed to be an employee if they were engaged direct and weren't engaged via an intermediary such as a personal service company. So the end user must then provide a status determination statement setting out whether or not the rules apply and the reasons for reaching that decision. The end user is also going to need to put in place an appropriate status disagreement process, and I'm going to talk through a bit more detail about that in a moment. It's important to note that the business using the worker's services is going to need to provide the status determination statement both in situations where they contract directly with the worker and also potentially where they source the worker via a third party, such as a recruitment agency, unless the agency has demonstrated quite clearly that they're paying the worker and making full PAY and NRC deductions themselves.
And David, just to say that on a later slide in this presentation, I'm going to be covering off some of the considerations that end users will need to consider when they are engaging these sorts of workers through agencies.
Yes, thanks, Lee. So just to wrap up, the determination statement itself will need to be provided to both the worker and the agency where an agency is involved. Where the end user of the services concludes that the rules do apply, then the fee payer, so that the entity who's ultimately paying the personal service company, is going to need to account for tax and NIC, including employers' NIC at 13.8%, and if appropriate, also the apprenticeship levy, and that's all done via the RTI system. It's important to note that the fee payer will not have any obligations to make pension auto-enrolment payments or other statutory payments, such as statutory sick pay, as the worker is not automatically regarded as an employee under these new rules. The fee payer paying the personal service company may be the end client itself, of course, if it's a direct engagement, or the fee payer could be the agency or another third party, such as an umbrella company, depending on the particular arrangements.
So moving on slightly now, David mentioned on the previous slide that these new IR35 rules won't apply to small end users in the private sector, and that's absolutely the case. The proposed carve-out for small end users in the private sector has been maintained, and this is going to be based on the meaning of small, which is given by the Companies Act 2006. Therefore, for the private sector, and subject to some complexities, which we'll highlight on the next slide, these off-payroll working rules will not apply to end users who are small. Now, an independent limited company that is not otherwise barred from being small, which, as I mentioned, we'll cover on the next slide, will be small where it meets at least two of the following three tests. So that's a turnover of £10.2 million or less, £5.1 million or less on its balance sheet, and 50 employees or less, measured by the average number of employees in the year. So if applying those tests, you are small as an end user, then the old IR35 rules will continue to apply. Now that means that the worker's PSC, not the end user of their services, will be responsible for assessing and applying IR35. Now these tests are considered for the financial year that is relevant to the tax year. Now, broadly, but with some exceptions, the financial year that is relevant to the tax year is the one with the 9-month filing deadline falling immediately before the start of the tax year in question. Now, for companies that are close to these thresholds, this will need to be carefully considered on an annual basis. Where a company meets or ceases to meet these conditions for being small on its balance sheet date, which is generally the end of the financial year, that affects its qualification for being a small company only if it occurs in 2 consecutive financial years. This means that a company which is a small company in one financial year, but then ceases to meet the qualifying criteria to be small, will only be regarded as medium or large size for these purposes if it does not meet the qualifying criteria for 2 consecutive financial years. Equally, a company not previously qualifying as small, which subsequently meets the small qualifying criteria, must meet those qualifying criteria for 2 consecutive financial years before it is reclassified as small. So there's much more to this than first meets the eyes. You know, these rules are quite complex and do actually require quite a lot of thought. Now, talking about complexities, there are a number of complexities around this small company exception to consider. I'm going to cover 3 on this slide. Firstly, there are rules in the draft legislation which mean that a company is always regarded as small for its first financial year. Secondly, some companies are always barred from being small, regardless of their turnover, their balance sheet total, and the number of employees they have. So, for example, public companies are barred from being small. Certain companies in the financial service industry are barred from being small. Members of groups containing traded companies are barred from being small, and they're barred under the Companies Act. And so, where the Companies Act stops them from being small, regardless of their turnover, balance sheet total, and number of employees, then they won't be treated as small for the purpose of these off-payroll working rules. Now, thirdly, the conditions for being small differ depending on whether the end user is a joint venture, a subsidiary of a larger business, an unincorporated entity, or indeed a company that is associated with another company. So as an example, take a subsidiary of a parent company, which is not otherwise barred from being small. Where the end user is a subsidiary of a parent company, the position for the subsidiary mirrors the position of the parent. So if the parent company's aggregated accounts, which are relevant to the tax year, are not considered small, applying a slightly different set of thresholds, then the subsidiary entity itself would also not be considered small for the purpose of these off-payroll working rules. Now, David mentioned agencies on one of the previous slides, and I sort of said that I'd be covering that. This is the slide where we are covering that. So these new IR35 rules, as David mentioned, will also apply where a public sector end user or a medium or large private sector end user sources such off-payroll workers via a recruitment agency or similar. So, for example, a situation where a medium or large end user requires the services of a worker, enters into a contract with a recruitment business to provide the worker, and the recruitment business enters into a contract directly with the worker's PSC, whereby it's agreed that the worker will provide services to the end user via their personal service company. Now, in this situation, we'd also normally expect the recruitment business to pay the worker's personal service company for their work, i.e., the recruitment business will be the fee payer. So medium and large businesses in the private sector and public sector end users will therefore need to identify all arrangements where these types of workers are provided via agencies and other similar third parties. They'll have to determine if that entity, that recruitment business, for example, is providing them with workers who operate via intermediaries such as personal service companies. Essentially, the end users will need to find out from the agency how the worker is being sourced and engaged. So in cases where the worker is operating via an intermediary such as a PSC, the end user will of course need to provide the status determination to the worker, but also to the agency or the other third party that they are contracting with. They'll also need to provide the worker and that agency with the reasons for reaching that determination. Now, the agency third party that is the fee payer will have to operate PAYE and NIC if it's determined by the end user that IR35 applies. If the end user does not exercise reasonable care in respect of their requirement to provide the status determination statement, for example, they don't identify that an agency that they're using is providing them with workers through a personal service company, then they could be deemed to be the fee payer for these purposes, and they could then be held responsible for the PAYE and NIC that is due. So it's therefore crucial that there's appropriate upfront dialogue with agencies and similar third parties to identify arrangements which are caught by these new rules.
Okay, thanks, Lee. I think at this stage it's worth kind of like taking a step back for a moment and just sort of summarising what we've already covered. So in summary, public and medium and large private sector end users of services will have the following obligations from 6th of April 2020. And just before I go through this, I just want to deal with one question that we've had already. So someone's asked, what is the difference between an end user and a fee payer? Well, basically, the end user is ultimately the public sector or the medium or large private sector business, which is actually using the services of the worker. And the end user may also be the fee payer. So if a business is engaging directly with a worker, they will both be the end user and also the fee payer of the services. But if there's an agency involved, the end user will be the client who's using the worker's services, and the fee payer, the person ultimately paying the personal service company, may be the agency. So hopefully that clarifies that point. So just going back to this slide then. So firstly, all impacted workers providing their services via an intermediary such as a personal service company will need to be identified, including those that are sourced via a third party such as an agency, unless the agency is operating PAYE and NIC already. The end user of the services is then going to need to make a status determination, and they've got to demonstrate that they're using reasonable care and provide a status determination statement, including the reasons for reaching that determination. And that has to be provided to both the worker and also to any other party that they contract with, such as an agency. The end user of the services will also need to set up an appropriate status disagreement process. So in the case of direct engagements, so an engagement between the end user and the intermediary direct, where the determination is that the rules do not apply, ongoing processes will still need to be put in place to review the working arrangements periodically in case that those change, which would have an impact. Where there is a direct engagement that is within the rules, then the end user, as the fee payer, will need to ensure that it obtains appropriate details in relation to the worker and put suitable processes in place to enable PAYE and NIC to be operated via the RTI scheme. I mentioned earlier that whilst the new rules are based on those that the public sector have been applying since 6th of April 17, or which they should have been applying since April 17, there are some important changes, and these are shown in the red boxes on this slide. So any representatives from public sector organisations on the call will need to review and update their current processes to ensure that they're providing a formal status determination statement that includes the reasons for that determination from 6th of April 2020, and ensure that that is passed to both the worker and any agency or third party involved. And then secondly, the public sector end user will also need to meet a new obligation of offering a status disagreement process from 6th of April 2020. So throughout the presentation so far, we've used the phrase personal service quite a bit, and I just want to focus on that for a moment. So it's important to emphasise that the legislation only applies where the worker personally performs or is under an obligation to personally perform services for a business. On this basis, the off-payroll working rules clearly don't apply where the contract is specifically for the provision of goods rather than personal services. The position where full services are contracted out to a third party can become very complex, and it's going to be necessary to review the arrangements very carefully on a case-by-case basis. Generally, though, if the arrangement does include provisions for the direct supply of personal services, then the company outsourcing the arrangements will still need to apply the off-pay working rules as the end user of personal services. Where, however, a company has fully outsourced the service and there are no provisions for a worker to personally provide services to that business, then the arrangements are unlikely to be within the new rules. So in this situation, the company taking on the outsourcing contract may, however, be the end user for the purposes of this legislation. So it's going to be important to ensure that certainly as a starting point, appropriate dialogue is entered into where a business believes that it has outsourced arrangements to another party. It's probably worth just running through a quick example of this. So the following examples hopefully illustrate that particular point. So if we take a scenario where X Outsourcing Limited has a contract under which it is asked by Y Limited to build and deliver a new computer system and provide support for 2 years, X Limited engages 5 workers operating via personal service companies to help implement this particular project. So in this scenario, Y Limited is not aware of how many workers are engaged, and no part of the contract or the agreement provides for X Limited to provide the personal services of the workers to Y Limited. Even though occasionally the workers might spend some time at Y Limited's office and maybe are given security passes, they only ever report to and carry out tasks requested by X Limited. So I think in this scenario, this is likely to be a contracted out service, and Y Limited would not have any obligations under the new rules as an end user. However, X Limited, who are actually engaging with the personal service companies, should consider the arrangements it has with those 5 workers, and it's likely that X Limited will have an obligation to operate the rules as the end user of personal services. If we contrast that with a situation where Y Limited instead said to X Limited they would like 5 workers provided to specifically work with X Limited's in-house IT team, and these workers are individually interviewed and report to the Y Limited head of IT, then this is likely to be the provision of personal services and within the rules. So in this case, Y Limited will need to meet its obligations as the end user. So whether an arrangement is the provision of contracted out or personal services is something that we're already getting quite a lot of queries on, and it's clearly going to be a contentious issue in relation to the new rules. Unfortunately, so far HMRC haven't issued any specific guidance on the matter, so we're hoping that that will be rectified as part of further technical guidance.
Thanks, David. So one of the other basic principles of the off-payroll working rules is that the legislation can only apply where the worker's intermediary, for example, the worker's personal service company, satisfies certain conditions, which are known as the conditions of liability. So after determining whether the service is the provision of labour or a composite contracted out service, if the end user concludes that the contracted out services exception does not apply and that they are receiving a supply of labour, the next step for that end user should be to consider and obtain details about the profile of the worker's intermediary. For example, is it a personal service company, or is it some other form of intermediary, such as an LLP, for example? And then once they've done that, to check whether those conditions of liability are met in respect of that intermediary. Now, those conditions will vary depending on the form of intermediary which is being used by the worker. So on this slide, we'll look at the conditions of liability that apply where the worker's intermediary is a company. Now, this is probably the most common form of intermediary that is used in these sorts of arrangements. Now, for a company, there are two conditions which must be satisfied for the legislation to apply. Condition one is that the worker or their associates have a material interest in the company. Condition two is that the non-employment income, payment or benefit arising from the relevant engagement can reasonably be taken to represent remuneration for services provided by the worker to the client. So as you can see already, this is all quite fiddly and complex. Now, material interest here is defined as meaning beneficial ownership of, or the ability to control directly or indirectly more than 5% of the ordinary share capital of the company, or possession of or entitlement to acquire rights to receive more than 5% of any distributions made by the company. And just to remind you, when I say the company here, I'm talking about the worker's personal service company, or where the company is a close company, possession of or entitlement to acquire rights to receive more than 5% of the assets available for distribution to participators in the event of a winding up of the company. Now, the material interest test will invariably apply where a worker operates through a single director service company, because typically in these sorts of cases, the worker and his or her spouse or another member of their family will own all of the share capital in the company. So it might be obvious in those sorts of circumstances that the conditions of liability and this material interest test are met, but it won't always be that obvious. It's also possible, for example, that the worker's shareholding will fall below the 5% ordinary share capital limit, and in such situations, the end user will need to consider the second condition of liability, which I mentioned and which is highlighted on this slide, which links the amount received or receivable by the worker to the amount paid by the client for the worker's services. Now, clearly, considering these conditions of liability, the end user is not always going to have all of this information, and they're going to have to request this from the worker. So when they do so, when an end user does that and requests this information, the worker is then going to be under an obligation to respond and provide it within a specified time frame. So once an end user has considered the contracted out services exception and concluded that that doesn't apply, they've looked at the conditions of liability and they've concluded that the conditions of liability are met, then they'll need to go on and consider the employment status tests in respect of how that worker is engaged. So at the heart of these new off-payroll working rules is the requirement, when the end user gets to this stage, to make a well-informed status determination in respect of the worker's services. Now, to do this, the end user must consider a hypothetical contract directly between them and the worker, which effectively ignores the worker's personal service company or intermediary. They must establish the terms and conditions, underlying working arrangements, and the other relevant facts for that hypothetical contract, and consider these in light of the status indicators which are relevant to determining whether a contract is one of employment or self-employment. Now, where the hypothetical contract is one of employment, the fee payer, on receiving the status determination from the end user, must then account for the tax and NIC due under PAYE when paying the worker's personal service company. Now, these status indicators have evolved over time from case law and are not set out in legislation, and there are more than 10 status indicators to consider. But the importance of each and how much weight each carries in isolation when determining status can vary. Now, arguably, the most important ones, the most important indicators here are right of substitution, mutuality of obligation, control or right of control, and financial risk. Now, the end user will need to consider these indicators, focusing perhaps on the more important ones that I've just highlighted, and consider them in respect of each engagement on a case-by-case basis. The approach is essentially to consider the overall picture which emerges on each, and then to make a decision about status based on the overall picture which emerges for each. So blanket status determinations for large groups of workers or a whole off-payroll workforce simply aren't the correct thing to do. Additionally, the end user must take reasonable care to consider status and pass the status determination and the reasons for it to the worker and the party they contract with. If an end user does not apply reasonable care, for example, they apply a blanket determination which proves to be wrong, then they can be held responsible for the tax, NIC, and any apprenticeship levy due. Now, these status determinations must, of course, be carried out at the outset of each engagement, and for current engagements which continue beyond April 2020, before April 2020, but also for longer term engagements, there's a need for ongoing review when something changes, or perhaps more sensibly at regular intervals to make sure that nothing is missed. Now, HMRC's check employment status for tax, or CESS tool, can be used for making status determinations, and indeed many end users in the public sector are already using this tool to make their status determinations under the off-payroll working rules which already exist there. The CESS tool has, however, come in for quite a lot of criticism recently. Many are taking the view that it's not fit for purpose in its current format and that it does not make accurate status determinations. And this seems to have been confirmed in a number of high-profile IR35 cases which HMRC have recently lost at tribunal hearings. Now, a particular criticism of the CESS tool is its failure to properly consider mutuality of obligation. This is based on HMRC's assumption that mutuality of obligation is already present in all contractual engagements, regardless of whether they are one of employment or self-employment. But this particular view has proved to be ill-judged by HMRC, as recent tribunal cases have taken a different view and highlighted how important mutuality of obligation can still be in determining status accurately. So while the CESS tool does have a role to play in helping users make well-informed status decisions, it's clearly not working as it should be at present and needs to be improved. Now, why HMRC stand by the tool as it is and claim that it gives a clear answer in 85% of cases, interestingly, they are still committed to improving it. They are therefore going to enhance the CESS tool and the associated HMRC guidance by the 6th of April 2020. Now, we understand that the improved or enhanced CESS tool will be available imminently, so watch this space for that. With regard to the guidance, we've already had some very high-level guidance, which was published on the 22nd of August, but we're really still waiting for the detailed technical guidance to follow, and that's the guidance that we all really need to apply these rules practically going forward.
Okay, thank you, Lee. So one of the things that we've mentioned so far is the requirement to set up a client-led status disagreement process. I just want to spend a few moments talking about that. So the government's confirmed that from 6th of April 2020, the legislation will set out minimum requirements for end users in the public and the private sector to offer and operate a status disagreement process. The government have said that in their view, the end user of the worker services is the person best placed to understand the working practices and the contractual terms and to be able to respond to any disagreements in real time. Some people felt actually that was passing the buck a bit, and perhaps HMRC should have taken this on, but that's the government's response. Under the draft legislation, the worker or the fee payer will be able to make representations to the end user who made that determination, setting out why they believe that original determination was incorrect. So the end user is going to be obliged to consider the representations and must respond within 45 days of receipt, advising either that they believe the original conclusion was correct, or if not, they'll be required to issue a new status determination. And clearly, they're going to have to think about how they manage that process and who is able to make that decision as part of this disagreement process. Now, at this stage, it's not clear what process should be followed if the original determination is changed. So, for example, if it's found that PAYE analysis has been deducted unnecessarily, it's not clear what the process is to deal with that. So it's going to be important for the end users to ensure that they do, in fact, have appropriate processes in place so that they can both deal with the representation and respond to it within 45 days, as failure to do so will result in the end user themselves being regarded as the fee payer and having those responsibilities. Moving away solely from the obligation of the end user, which we've talked about in quite some detail, this slide shows the obligations of each party in a labour supply chain under the new rules, and this is taken from one of the HMRC documents. So on this slide, you can see that the end user of the services, so in this case referred to as the client on this slide, the end user of the services is required to make their status determination and to then pass that determination and the reasons for it to both the worker at the end of that chain and also to the party that they contract with. So in this example, that is Agency 1. Agency 1 is then required to pass the status determination statement and the reasons for it down the chain until it reaches the fee payer. If the determination states that the worker is deemed to be an employee, so the rules apply, the fee payer must then account for the tax, employees and employers NIC, and where appropriate also the apprenticeship levy via RTI, and pay the worker's personal service company after these deductions have been made. The liability for the tax and the NIC moves down the labour supply chain, and it sits with each party in the chain until such time as they meet their obligations. So if a party doesn't satisfy its obligations in the chain, then it will itself be held responsibility for the liability. So for example, if Agency 1 in this case does not pass the status determination to the fee payer, then Agency 1 will be held responsible for any tax and NIC due. This is going to be of particular interest to recruitment agencies, for example, which sit between the end user client and the worker's personal service company, as they will need to ensure that they have appropriate processes in place to meet their obligations.
So that sort of moves on, I think, quite nicely to the transfer of liability provisions. So the draft legislation and the government's response to the consultation confirms that the probably quite controversial transfer of liability provisions will form part of the new rules from 6th of April 2020. So as David highlighted on the previous slide, the liability for the tax, NIC, and potentially of the apprenticeship levy due under PAYE, where a worker is deemed to be an employee, passes down a labour supply chain, as each party satisfies its obligations under the new rules. Now, the transfer of liability provisions will potentially allow HMRC to transfer the liabilities to an agency at the top of the labour supply chain, i.e. the first agency which has the direct contract with the end user client, or to the end user themselves, where there is non-compliance further down the labour supply chain, and it's not possible for HMRC to collect the amounts due from the offending party, being the party that doesn't actually meet their obligations. Now, HMRC have stated that these transfer of liability provisions will only be applied in certain circumstances, for example, where tax avoidance is involved, rather than where there is, for example, a genuine business failure. HMRC guidance setting out the circumstances in which they will seek to apply these liability transfer rules will be issued hopefully shortly, and HMRC will also outline the steps which organisations can take to ensure due diligence on their internal processes. So let's have a look at an example of how this works. And again, this example is taken from one of the HMRC documents. So in this example, the client on the left-hand side of the slide undertakes the status determination and passes this determination and the reasons for reaching it down the chain to the party they contract with, being Agency 1 on the slide. They also pass the determination to the worker, although we've not shown this on the slide for the sake of simplicity. Now let's assume that the status determination deems the worker to be an employee. So Agency 1 passes the determination and the reasons for reaching it to Agency 2, and Agency 2 passes this down to Agency 3. The process breaks down, however, where it reaches Agency 3, who fail to pass the determination and the reasons for reaching it to the fee payer. The offending party is therefore Agency 3, so they are initially held responsible for any liabilities due. If HMRC cannot collect the PAYE liabilities due from Agency 3, under the transfer of liability rules, they'll be able to transfer the liability back up the chain to Agency 1. Now, if Agency 1 are, for example, outside the scope of PAYE, they're outside the territorial remit of PAYE, and HMRC cannot collect the PAYE liabilities from agency 1, then they'll be able to transfer the liabilities to the end client themselves. Now, as I said, we don't know exactly how this will work at this stage. What is clear, though, is that the end clients using the services of workers via their own intermediaries, and also agencies at the top of labour supply chains, they'll need to be particularly mindful of these rules and whether they can apply where workers are sourced through longer labour supply chains. The end client and the first agency will need to understand the labour supply chain and ensure that parties further down the chain are aware of and meet their obligations under the rules. They might also need to consider protecting themselves from unexpected liabilities, for example, by introducing indemnities into contractual arrangements, and also perhaps seeking appropriate insurance cover. Now, there's a final complexity to consider. And the rules can be particularly complicated where there are international considerations. And where this is the case, it's probably likely that some degree of professional advice is likely to be required. Now, this is an area where detailed HMRC guidance is currently quite lacking. And this is really probably going to be much more of an issue for the private sector than it has been for the public sector. And so we're hoping that detailed guidance on the international aspects will form part of the technical guidance, which we hope will be issued by HMRC shortly. Now, there can be a number of different scenarios where international complications might occur. For example, the fee payer themselves might be outside of the UK, or the work might be performed overseas, or the worker themselves might be residing overseas, or might be providing their services through an overseas intermediary, or indeed there could be a sort of a mix of a number of those different sort of the facts. But let's have a look at this slide, an example where the fee payer is based outside of the UK and how that can complicate the position for the end user. So in the example, we have an end user in the UK who isn't small, who contracts with an overseas agency. The UK end user is the highest person in the chain. Now, under the contract, the overseas agency provides the UK end user with a worker. The overseas agency, which is also the fee payer, then engages with that worker's personal service company. So the personal service company is the lowest person in the chain. And in this case, the worker performs the work wholly overseas. So you've got a UK end user who's been provided with a worker through an overseas agency where that worker's providing their services via their own personal service company. Now, the end user in the UK must initially assess whether the worker would be deemed to be an employee. Now, that's assuming that the contracted out services exception doesn't apply. It's assuming that the conditions of liability are met. So they have to consider if the employee were providing their services directly under a hypothetical contract, whether they would look like an employee. And then they're required to give their status determination to the worker and the overseas agency. Now, the overseas agency is the fee payer sitting in the chain between the highest person in the chain, the UK end user, and the lowest, being the personal service company. But the complication here is that the overseas agency is not treated as a qualifying person for these purposes because they're not resident in the UK and they don't have a place of business in the UK. Now, as there is no qualifying person in the chain below the highest person, the UK end user, and the lowest, the personal service company, then in this example, the UK end user will be regarded as the fee payer. So if IR35 applies, the UK end user then needs to consider operating PAYE. They'll also have the additional complication first of considering whether the worker is a person within the charge to UK tax and liable for NIC. So I think this example really illustrates how complex the rules can be, where a relatively straightforward international aspect is inserted into the circumstances. In this case, an overseas agency, and this is something that end users are going to have to be particularly mindful of.
Thanks, Lee. So I think as we've demonstrated throughout this presentation, it's not straightforward, and the proposed new rules will place significant obligations on medium and large businesses in the private sector who use the services of workers operating through these intermediaries such as personal service companies. Public sector entities will also need to review and update their current processes, so they need to be particularly mindful of the fact that there are changes for them as well to be compliant with the new rules. So as a starting point, from a practical perspective, we would suggest that private sector businesses using the services of off-payroll workers should identify whether or not they are an exempt small business, taking into account the complexity involved that Lee described earlier, and also taking into account whether a new business or part of a group. It's then going to be really important to identify all existing arrangements with off-payroll workers, including those sourced via an agency, and assess whether or not those arrangements will be within the new rules, and if so, work out the potential cost impacts. Just to reiterate on that point, these rules don't apply where the worker is an individual. So we've had one query around that. As we said at the start, if you are engaging a worker who is an individual, separate rules apply. Payroll and account systems and processes are going to need to be reviewed, and they're going to have to be updated and tested as necessary to ensure that obligations for identifying appropriate invoices coming in and for then accounting for the PAYE are met. And where an arrangement is covered by the new rules, the fee payer is going to need to introduce a process to gather the appropriate information in relation to the worker in order to operate PAYE and NIC via RTI. So, for example, a decision will need to be made as to whether the off-payroll workers will be added to your main payroll, or whether it's easier to set up a new payroll scheme. And a process will need to be put in place for completing a new starter declaration. And also at the end of the contract, it's going to be necessary to provide the worker with a P45. It's also going to be important to consider the legal implications of all this. So, for example, if it's decided to amend or to terminate an existing contract with an off-payroll worker, or where it's decided that the off-payroll worker should in fact become an employee of the end user, then it's going to be really important to consider all of the legal implications around all of that. And finally, it's important to ensure that you provide appropriate communication, both to the off-payroll workers themselves and your own teams who may be hiring these people, particularly around what your approach to the new rules is going to be. Now, we know from practical experience, lots of queries are coming into clients from the workers they engage, and it's really important as early as possible to make sure that you get some appropriate communication out to them. So how can we help? So within RSM, we've got a team of specialists with significant experience of helping clients prepare for all aspects of the new rules from 6th of April 2020. We're also able to call upon the employment law specialists within RSM Legal to consider the employment law implications. Just by way of example, we're currently working with many clients to help them with all aspects of their preparations, including initial facilitated workshops for all stakeholders within the business. And these are particularly valuable in helping to raise awareness of what the changes are, but also to consider the practical considerations that need to be dealt with prior to 6th of April 2020. We're also providing assistance with the status determination and the status disagreement process itself, and helping clients with the preparation of appropriate communication material, both internally and to the off-payroll workers. and of course also providing assistance with various ad hoc queries that are coming in. Just a final point on here, further details of how we can help and our latest insights, which are being updated on an ongoing basis, can be accessed at www.rsmuk.com/IR35. So that concludes the presentation, which we hope you found useful, and appreciate it is quite detailed. We have had a whole load of questions come in during the presentation, and we will try and deal with a few of those now, but I'm conscious of the fact that we haven't got a huge amount of time. So on this slide, you can see our contact details. So if you would prefer to raise your query with one of us, please take a note of those contact details. But let's sort of go through some of these points now.
Yeah, so I've got some questions in front of me. So one of the questions raised was, does the agency have responsibility to seek out a status determination statement from the business they are supplying workers to? Well, officially not. No, it's the responsibility of the end user themselves to provide the agency with that statement. But actually, in practice, what we'd expect is sort of a bit of a joined up approach from the agency and the end user, whereby they're talking about these sorts of arrangements, identifying potential cases that are caught and agreeing what each party will do. So, for example, that the client knows that they've got an obligation to consider the rules, and that the agency will receive the status determination. Indeed, a lot of the agencies that we talk to, a lot of them actually think that they might actually be asked by their clients to actually help them with the status determination itself in certain circumstances.
I would just add that from discussions I'm having, I think it's really important that whether you're an end user of the services or an agent, you ensure that there is dialogue between the two. And I'm hearing from agencies that they are not perhaps getting the traction with their clients, but equally I'm hearing from clients that they're not hearing from their agencies. So there is a bit of a disconnect there. And so I think, yeah, I agree. I think that the most important thing is that there is dialogue between the two. I've got one here. At what date must the end user of the services provide workers with their first status determination statement, assuming that the business isn't small? So basically, the guidance from HMRC is that the determination statement should ideally be given at the time the contract is entered into, or failing that, it must be provided before the work begins under that contract. So that hopefully answers that point.
So an interesting question here regarding the first example that we gave in our slides regarding the contracted out services exception. To confirm, if X Limited are working on the first model, do they need to provide a status determination statement to their personal service company contractors? Well, I think so. In that example, I think it's very likely that X Limited would. I mean, assuming that those contractors are providing X Limited with their personal service themselves, and the conditions of liability are met in respect of those contractors' personal service companies, then yes, X Limited will then need to assess their status and provide them with the status determination statement.
Yeah, a quick question here. What about charities? So we've spoken today about the fact that yes, rules applied for public sector entities, so entities covered by the Freedom of Information Act that are regarded as public authorities, and we talked about corporate businesses. What about charities? And I think what has been said around that is that specific provisions will be made for testing unincorporated businesses as to whether or not these rules apply. So the government has said that they will simplify the test for unincorporated client organisations, and the simplified test will consider turnover for a calendar year only, so that unincorporated clients with turnover exceeding 10.2 million will be within the scope of the reform. So there's no specific exemptions for charities other than that. I'm conscious that we've now run out of time, and we do have a whole load of additional questions. So as I say, hopefully you can see our contact details on this particular slide. Or as I said at the start, please speak to your normal contact. Apologies if we haven't answered your question, but we'll be pleased to do so if you could make contact. So that completes today's webinar, and we hope you found it useful. Thank you.